Justices of the Constitutional Court, all counsel are online. I call the matter of Centre for Child Law and Director of Public Prosecutions, Johannesburg, and others for hearing. Counsel are now invited to place themselves on record. Please note that this hearing is being recorded.
Mr. Courtney.
My apologies, Justice. I'm not sure what was happening there. Indeed,
yes.
Justice, I confirm my appearance on behalf of the applicant in this matter, the Centre for Child Law.
Thank you, Mr. Courtney.
Justice Madlanga, I just want to check because the counsel for the first respondent said he'll be joining the matter, although they are abiding. But if I may just confirm my appearance on behalf of the second to sixth respondents together with Ms. Natalie Buthelezi.
Thank you very much, Ms. Raja. Yes, Mr. Courtney.
As the court pleases, Justice Madlanga, this is an application for confirmation of the ruling by the Gauteng Division of the High Court, Johannesburg, that Section 4B of the Drug and Drug Trafficking Act is constitutionally invalid to the extent that it criminalizes the use and or possession of cannabis by a child. I think it's important to stress, and I'm sure that my colleague will do the same in her address, that this case is not about whether or not children should be allowed to use or possess cannabis. It is rather whether it is constitutionally permissible for children to be subject to criminal sanctions in order to prevent and deter them from using cannabis. Justice, these being confirmatory proceedings, this court must decide whether the High Court was correct in its finding. If it finds that the High Court was correct, then obviously it would follow that an order of constitutional invalidity should be granted. I will, during the course of my oral address, seek to deal with three broad issues that I believe are of importance. The first is I will begin by dealing with the crime as the High Court did through the lens of it constituting a status offense. And I will seek to show that as a status offense, the crime does not pass constitutional muster. I will thereafter deal with the crime through the lens of appropriate measures, as I had defined it in the submissions before this court. That being the international standard against which all drug policies vis-a-vis children must be assessed and determined with reference to. The need to do this is threefold. One, it serves as an alternative basis for this court to consider declaring Section 4B unconstitutional. Two, it serves as a useful benchmark to interpret and implement the less restrictive legislative options identified by the government respondents, that being the second to sixth respondents. Three, and perhaps most importantly, is that it serves as a guideline to the legislative process that the government respondents have advised is currently underway. And we would submit that guidance ought to be derived from the judgment of this court to the extent that it is in agreement with my submissions on that score. Finally, I will seek to provide a very brief commentary on certain what we perceive to be erroneous and dangerous beliefs held by, amongst others, the Minister of Social Development in their reply and as articulated in my learned colleagues' submissions. So with that said, Justice, the constitutional mischief identified by the High Court was that the crime of possession and use of cannabis constituted a status offense. That is a crime that criminalizes the action of only a certain group of people, most commonly on the basis of sexuality, religion, or age. Generally, these characteristics are things that are outside of the immediate control of the person who is being criminalized. This constitutional mischief identified by the High Court flows directly from this court's findings in the Prince matter that effectively decriminalized and to an extent legalized the possession of cannabis in certain defined circumstances by adults. That judgment was solely aimed at adults and adults only, this court making it clear that it did not and would not pronounce on the issue of children. The effect, though, of that judgment is that, and insofar as children are concerned, is that criminalization is no longer based on deviant behaviors that are considered to violate the prevailing social norms, but rather solely based on age and timing. And we submit, much like the High Court found, that this can never be constitutionally appropriate. It is not only at odds with the international and regional law, but it also violates several fundamental rights of children, most notably...
Mr. Courtney, excuse me.
Yes, Justice Matata.
Sorry to stop. Am I correct, Mr. Justice Presiding, that we may interrupt Mr. Courtney? Okay, thank you.
Yes, my sister.
Thank you. I just wanted to find out, just to confirm from you, Prince dealt with possession and use in private. So we are only concerned about usage and possession of small quantities of cannabis in private, even in respect of children. Is that correct?
No, Justice. I think the High Court didn't necessarily draw that distinction. It dealt with the kind of general consensus of being in possession of cannabis in broad brushstrokes wherever a child may be found. Indeed, there is something to be said, I guess, insofar as quantity is concerned. But I would think that would be more on the basis of whether the quantity in a person's possession is sufficient or is so much that it wouldn't constitute for personal use. But what we're dealing with here, Justice, is the crime of being in possession of cannabis as it is currently on the statute books in terms of Section 4B. What we are not dealing with is growing or possession of larger quantities, which may indicate the intention to sell or distribute. I'm not sure if that clarifies your question, Justice.
The reason why I'm asking this question is that the minister in his papers seems to be saying the use and possession of cannabis in public is still a criminal offense. So my concern is in respect of public and private usage. What is your case and how far are we going in this particular case?
Justice, if the starting point, which it must be, is that this case is not about children being allowed per se to possess or smoke cannabis, it matters not whether it is in private or public. This court drew the distinction between private and public on the basis of the person using it. Now, what this case is not about is about children using or allowing children to use and possess cannabis. On the contrary, what this case is about is saying that a criminal sanction is it cannot be justified when it comes to children under the guise of prevention and deterrence. And I'll explain why from a preventative and deterrence point of view a bit later, why it is common cause that the offense itself does not tick either of those boxes. But in a nutshell, effectively, the distinction that this court drew between private and public is irrelevant for purposes of making the assessment currently, because it is not as if this court will be condoning or authorizing children to to use or possess cannabis in their own homes, which was the kind of caveat that this court had built into its judgment. We're not concerned about that. I'm not sure whether that explanation.
Just one last point from my side on this aspect. If you talk of a status offense, we have to take Prince and determine what Prince said and compare that to what is the situation insofar as the children are concerned. We know that Prince dealt with private usage and the children are excluded there. So the status offense would be applicable in that instance. So for the other part, we'll have to look at the other rights that may be implicated to reach the outcome that you want.
Indeed, Justice, and hence why I propose the alternative basis in my submissions, that it is not only because it is a status offense, that it is constitutionally undesirable to punish children who may be found using or possessing cannabis. And that is an aspect that I will address comprehensively during my address.
Thank you, Justice Madlanga.
Thank you, Mr. Prince. If I'm sorry, Mr. Courtney, if I may. You said one is not really concerned about the public-private nature of the debate. But if indeed one has regard to the order of the High Court, it's simply a declaration that 4B is invalid to the extent that it criminalizes the use and or possession of cannabis by a child. That's an unconditional declaration of invalidity. If we're asked to confirm that, do we not run the risk that you say we must avoid by creating a status offense? Because the effect of that will now be to swing the pendulum almost to the other side, that there be a limitation with regard to the manner in which adults may possess and use cannabis, and that's largely in private, but the same restriction would not apply to children. And now you sort of move the imbalance from one side to the other. So should we not be concerned that indeed, if we are to confirm the order of invalidity, it should at least be consistent with what this court did in Prince, and to the extent, and no more, that children were excluded from the order in Prince, they should be included. And that should be the scope and extent, and therefore the order of invalidity should be confirmed with those caveats. What do you say about that? Otherwise, you run the real risk that you're going to have two different regimes, one for children and one for adults.
Justice Copeland, I think my answer to that question would be, one, I don't believe that one can create kind of a reverse status offense in the way suggested. And I say that because as a matter of law, and a matter of constitutional law at that, we accept that children must be treated differently. And there is a long list of authority by this particular court where this court identifies why there is a need to treat children differently. A good example off the top of my head would be the decision of this court in J. J dealt with registration on the sexual offenders register. And there the court found that insofar as there is an automatic placement on child offenders, the automatic registration following a conviction on child offenders, that would be unconstitutional because they merit our special protection. So I think that the inverse by creating a system specifically geared to children, I do not believe that we run the constitutional risk of infringing on the rights of adults. They are deserving of special protection. And in fact, their rights and the rights that are engaged are unique to them.
Mr. Courtney, let me just put the scenario to you. So in paragraph 2, the High Court said, pending the completion of the law reform process, no child may be arrested and or prosecuted under and or diverted for contravening the impugned provision. Practically, that would mean that if tomorrow a child is found in possession of a bag of cannabis, that child is immune from prosecution. But if an adult is found with a bag of cannabis, let's say both are found in a public place, that adult would not be immunized from prosecution. Surely that could never have been the intention of ensuring that Section 4B's invalidity is applied in a constitutional context in a manner that's fair, consistent, and takes into account the special needs of children, I would say that there's no special interests of the child that are triggered in seeking to create an unconditional immunity, as it were.
Thank you, Justice. Justice, I would respond by saying the following. What I don't believe that the applicant or any of the respondents are saying is that in relation to children, we do nothing. And in fact, the government respondents set out in quite detail the mechanisms that would apply. And particularly, they identify the Children's Act. Once again, it is an act that is solely directed at children. So in that example, one would think that if a member of the SAPS found a child in possession of a bag of cannabis, that inquiries would be made and that a social worker would be informed, as is, and that the processes envisaged in the Children's Act would be embarked upon, because that, insofar as children are concerned, is a less restrictive and a more advantageous approach to dealing with the problem of substance abuse. Whereas an adult, the considerations are different. One need not consider, for instance, when discussing adults, what impact the arrest would have on that particular person. And
Courtney, I hear you that there might be some consequence, and this is just the last question I want to put to you. It's simply that in assessing what would be the most appropriate intervention, the order of invalidity that we're asked to confirm would simply mean that the option of prosecuting a child, irrespective of how serious the extent of the possession might be, would be closed to the state pending the law reform process. And I just find that problematic if one compares it to what Prince sought to do. But I think you've responded. Thank you.
Thank you, Justice.
Mr. Courtney, I wonder if I could follow up my brother's question. I think you accept that the justification for Prince cannot be of application to children because they don't have a right of privacy to use cannabis at home. So if that is true, and you seek the kind of broad brush immunity that the order of the High Court seems to presuppose, it would allow children to become drug runners with complete immunity from prosecution and as pawns of criminal gangs engaging in large-scale drug distribution.
Justice Utolta, I must disagree with the statement, and I disagree with the statement in that, once again, what we are not saying is that children should just be left to their own devices when it comes to possession of cannabis.
Look at the order that we are sought, that confirmation of which is sought. It's not that there may not be other measures that would be appropriate for children, but the wholesale decriminalization in any form and in any circumstances of the possession of cannabis by a child permits of children's abuse at the hands of gangs and others who are engaged in widespread forms of public harm. Now, are you saying that the only response is one under the Children's Act and the criminal law should have no response in any circumstances of a child essentially becoming a drug runner?
Justice Utolta, to the extent that criminal gangs, and I unfortunately have no evidential basis for that, but to the extent that it does become prevalent, the Child Justice Act makes specific provision for children who use adults who use children to commit offenses. And there is nothing to say that the people who make use of this particular child cannot and should not be arrested. It is not to criminalize the children for the sake of protecting the children from a potential abuse. I think that with respect can never be so. One can never criminalize somebody to protect that very same person. from whatever external harms may come to be.
Isn't that a very debatable issue of public policy and engages questions of limitation that thus far haven't been very fully traversed on the papers before us?
I accept that it certainly is an issue that is open to debate. My submission in response, though, would be that in our view, the seeking to criminalize children to dissuade adults from using them is respectfully putting the cart before the horse. I'm trying to. I may return with an analogous example that is on the tip of my tongue, but I cannot immediately
give it some
recall.
thought. You may want to come back to the point. Thank you. I've heard your response.
Mr. Courtney, excuse me. Before you leave that point, if you look at paragraph 2 of the order of the High Court, the problematic parts would be no child may be arrested and or prosecuted. Don't you think there could be a way in which we could refashion the order that has been made by the order of the High Court? Because as my brothers have put to you, the non-prosecution and the non-arrest has far-reaching implications.
Indeed, Justice Matopo, I certainly do think that the concerns that have thus far been raised seem to sit quite squarely in the remedy that was given by the court in paragraph 2, the blanket prohibition. The blanket prohibition was done obviously by the High Court exercising its just and equitable relief, its just and equitable power. If this court believes that in itself is problematic, then it can certainly be revisited. And I will certainly give thought, and perhaps I could be given an opportunity to ponder it, and then in reply, perhaps try and come up with a solution that addresses some of the concerns, at least, that have been raised by the other justices. Turning back to the submissions and dealing with them through the lens of status offence, what becomes quite clear in the High Court judgment is that there are at least 3 rights that are violated by the criminalization of cannabis. That is the right to equality, the best interests, as well as the right to dignity and freedom of security. Now, the High Court did not directly engage on the issue of human dignity and freedom of security, but we would submit that any discussion about a status offence is incomplete without reference to those particular rights, and particularly that the arrest on the basis of a status offence is always arbitrary and capricious. And that, in fact, finds resonance in what the African Union has noted. And as pointed out, I think, in the judgment itself, in the discussion of the regional law. So we submit that as a status offence, it is problematic, that it is unconstitutional. Turning to the crime and criminalization more generally, the crime and criminalization more generally does not constitute, in our view, an appropriate measure. In this regard, Article 30 of the Convention on the Rights of the Child, which South Africa is a signatory and has ratified, provides that state parties shall take all appropriate measures, including legislative, administrative, social, and educational measures to protect children from the illicit use of narcotics, drugs, and psychotropic substances as defined in the relevant international treaties, and to prevent the use of children in the illicit production and trafficking of such substances. Article 30 is important for two reasons. Firstly, it places a positive obligation on the state to ensure that its response to any drug problems meets this threshold. Secondly, this court is constitutionally enjoined to interpret the implicated rights, and Section 36 for that matter, through the lens of Article 33. In order for a crime and any contemplated criminalization to constitute an appropriate measure, it must pass two tests. It must be rights compliant and it must be effective. The amicus submits that it fails on both legs of the test. Insofar as the first leg is concerned, the crime generally violates the right to dignity, the right to healthcare and social services, and a child's right to have his or her best interests considered of paramount importance. The second leg of the crime and criminalization generally is that it is ineffectual. The criminalization of cannabis use and possession does not prevent cannabis use amongst children, nor does it deter children from using cannabis. This is in fact common cause between the parties. For instance, in summarizing the government respondent's position, the heads of argument filed in this court say, for instance, at paragraph 46.3, that there is no evidence to indicate that criminalization and incarceration would deter children from using cannabis. At paragraph 49.2, it's recorded that even though the Minister of Social Development acknowledges that Section 4B of the Drugs Act serves as a deterrence against the use of cannabis by children, she submits that it is not an effective and appropriate manner of addressing the problem of drug use in South Africa. Similarly, the evidence put up by the National Prosecuting Authority in defense of the drug child program in the High Court also tends to show this. There is an affidavit that appears in volume 1 at page 13, volume 2, page 132, my apologies. It is an affidavit deposed to by a social worker who is employed or was involved in the drug child program. And there what the social worker does at paragraph 8 is tabulate the results of this particular intervention. And there, if we have regard to the period 2014, 2015, 2016, 2017, 2018, the table starts off by saying the number of drug tests performed, and immediately below that, the number of learners who tested positive. Now, if we use that as, for instance, a benchmark, what we see is that the positivity rate, that being the amount of tests versus those that tested positive in that particular school, remains fairly constant at about 40%. So in 2014, it was 41%. 2015 is the outlier at 33%. 2016 is at 40%. 2017 is 43%. And 2018 is 43%. And what we would say that what that effectively demonstrates is that despite this drug child program being part of this particular school's disciplinary policy, that the amount of children becoming involved did not drastically decrease, despite the use of the criminal justice system to try and solve the problem.
Mr. Courtney, The Prince case, as I understand it, was not willing to countenance the lack of deterrence as a basis for decriminalizing the use of cannabis outside the home. You are asking us, nevertheless, to accept that proposition for the purposes of children. So you are actually requiring us to go considerably further than Prince did. Is there a basis for that? Why should we countenance evidence around deterrence in this circumstance as to children when it wasn't an argument that prevailed in respect of adults and Prince?
Just to alter, the reason for that is that unlike adults, the Convention on the Rights of the Child specifically deals with what it considers to be an appropriate measure. And that is the yardstick as a matter of international law, which drug policies, insofar as children are concerned, must be weighed against. I'm unsure, and I cannot say with any certainty, whether there is a similar or like provision that would be of assistance to adults. And once again, the differentiation between adults and children is constitutionally defendable. They are deserving of special protection. They are deserving of different regimes that cater for their growing personhoods, as this court, for instance, mentioned in M and is cited in my heads of argument. So that would be the reason I would say that this court is entitled and ought to go further than that which it did in Prince, when assessing this through the rubric of Article 33 of the Convention on the Rights of the Child, because that is what Article 33 requires of us and imposes on the state insofar as its obligations are concerned.
If there was some deterrent effect that criminalization had, would that not be protective of children?
Before you respond, Mr. Courtney, the 30 minutes is up. How much more time do you want?
If I could possibly get 10 minutes, or if I'm not asking too much,
I'll give you 15. Please respond to my brother Justice Underholter's question.
Thank you. If I understand the question correctly, I don't think that it follows that by mere criminalization there is any deterrent effect, and there doesn't seem to be any evidence.
The premise of my question is assuming there was a deterrent effect.
Just I'm not too sure. I'm not too sure whether it would operate in favor of a child or otherwise. What we know is that children are going to be pushing boundaries. Children are going to be doing certain things. And I think that a better indicator as to whether or not there would be any deterrence would be on the house that they are raised in, their family and community settings would serve as a deterrent before any criminal sanction would serve as a justify or serve as a deterrent for children. But I have obviously no evidence to back up that submission. But I would think that would be the case, much like children engaging in sexual intercourse with one another, as discussed in Teddy Bear Clinic. I think the considerations would be the same. It's not that the law as a blunt instrument simply deters children from engaging in sexual relationships merely because it is a crime. It is a product of their upbringing and social setting that will influence their decisions in that regard.
Yes, thank you.
Continue, my sister.
Thank you, my sister. If the criminal sanction is removed, now how will this child be dealt with? I know there's mention of the Substance Act, the one that's called PTSAA, and the Children's Act. How and if you look at para 2 of the order, which says the child must not be arrested. Now, how will that child be dealt with if there is no arrest? And just if you can explain to me the process, please.
I think the processing of the child depends very much on the factual circumstances that surround the commission of the offence. And it brings me to a point that I had left for last, but perhaps it is a point that I should just simply get out of the way here, considering time is also not on my side. And that is what the Children's Act and what the Prevention of and Treatment for Substance Abuse Act do is that they allow for particularly the Department of Social Development, but in conjunction with members of the South African Police Service and others, to assist children who are caught up in a cycle of drug abuse. The position would be that a child who is found in need of or is found in possession of cannabis, that the child would likely be, would be reported to the relevant Department of Social Development for them to investigate and to determine, is this child in need of care and protection? So one would not, as the submissions for the various government respondents suggest, one would not simply grab the child and drag the child off to a treatment center under the guise of care. What one would do is take a holistic approach and refer the matter for there to be an investigation. If it is found that the child is addicted to cannabis, then what the Children's Act, read with the PTSA Act, does is it provides a mechanism for connecting that child with either inpatient or outpatient treatment so that they can overcome their substance abuse issue and thereby hopefully break the cycle of substance abuse. If the investigation reveals that, well, this particular child was merely experimenting, it will interrogate, in terms of the Children's Act and the processes under the Children's Act, in determining whether or not this child is in need of care and protection, it will interrogate whether or not the home circumstances are perhaps not conducive or creating an enabling environment for this kind of behavior. And there, the magistrate in the Children's Court would then have to make a decision as to what is the best way to deal with this. Is it a lack of knowledge and insight by the parents, in which event the Children's Act authorizes the magistrate to compel the parents to undergo some form of kind of parental training. And thereby one would hope that the cascading effect of that would be that once the parents understand the dangers and understand the problem, that they in turn would be able to assist their particular child. Or there may be need for other interventions under the Children's Act. So it is not to say that we simply do nothing. It is rather to say that there are these systems in place. And what these systems allow for is a holistic and non-punitive approach to solving the problem of what has led to this child being in possession of cannabis.
Thank you, Mr. Courtney. Thanks, my sister.
Thanks, through you, Justice Madlanga. Just briefly on what my sister has asked you. And it turns on remedy. If we're inclined to grant an order that takes into account what my brothers have already raised with you, the concerns that they've raised, and I've got similar concerns. If we're inclined to grant an adjusted order that takes care of those, what about retrospectivity? What about children who are already on diversion programs? And what about children who have already been arrested? How do we cater for those?
Thank you, Justice Tiki. Strictly speaking, children should not currently be in the criminal justice system if regard is had to paragraph 2 of the order. There ought to have been no arrests and prosecutions if the order was strictly complied with. So this court's order would need to only be forward-looking in that regard. Insofar as,
sorry, Mr. Courtney, I'm asking specifically in regard to children who were in the process, who had already been arrested and who were undergoing a process, the criminal justice process. Because I see that paragraph 2 does not deal with them. This is why I'm asking this question.
Indeed. I think that the answer to that is that unfortunately a line needs to be drawn in the sand, and that the order would be prospective only. I must say that I cannot think, and I stand to be corrected. And unfortunately, the representative of the first respondent is not present, because perhaps he could have shed some light on what the current status is in relation to children who have been arrested for cannabis use prior to the order is concerned, and how many there are. But and to the extent that it is a yardstick, and it's a poor yardstick at that, is that my gut instinct would be that there aren't the likelihood of there being any children in that position at the moment who are currently undergoing some form of diversion program. There ought to be none. Those programs do not run for many years. They're generally done on over the course of weeks. And considering that this judgment was granted already, I believe, in 2020, though whichever children were caught up then are likely to be have finalized their whatever process by now. I'm not sure if that answers your question to your satisfaction. Unfortunately, I can't really comment much further. I do think that a line would need to be drawn, acting prospectively in respect to those matters.
Mr. Courtney, if my sister has completed.
Can I just finalize just one minor thing, my sister? I see that in your words, you don't deal with the last part of paragraph 2 of the order of the High Court. I just want confirmation from you that you support it.
Indeed, Justice, we certainly do support there being an interim measure in place, and we support the order as is. But as I indicated earlier, I will also give some thought to how to modify it in order to allay certain concerns that had not been thought of when that particular order had been originally handed down.
I did allude to the fact that I support the concerns that were raised by my brothers. But when you do reflect on the issues that they asked you, you must keep in mind that when we talk of children, we're not only talking about young children. We're also talking about adult children, and I'm referring you specifically to the question that my brother Unterholter posed to you, that we have to keep that in mind in whatever order that we would be inclined to grant. Thanks, Justice Madlang.
Thank you, Mr. Courtney. To follow on from the questions of my sister, Justice Chitli, and this concerns with whether the declaration of invalidity, if this court was to confirm it, should have prospective effect or retrospective effect. What about children who have already been convicted under this act? Is it in the best interest of the child that they maintain a criminal record?
Justice Theron, I think I certainly cannot make the submission that it is in their best interest that their criminal record forever be marked by this particular crime. I think that children who have been convicted, and obviously this particular matter did not deal with a child who had been convicted, but rather for children who had been diverted. And unfortunately, that diversion changed into a residential diversion program. But so I once again, I do not think that if this court declares the crime unconstitutional, that it would necessarily be in the best interest for children who had previously been convicted of the offence for their name still to be tainted. However, to cure that problem, I think is difficult. And the general position adopted by this court insofar as those kind of matters are concerned, and the only outlier I believe is the National Coalition case, is that it is prospective in effect. But perhaps the saving provision is that any child that may have been convicted of this offence, that they may apply for an expungement if it is necessary. And in that way, one doesn't need to retrospectively declare the provision unconstitutional, but it affords them the right of expungement, which they can then exercise in their own time. I'm not sure
if that was to be a possibility, it would need to be dealt with by an order of this court.
Indeed, Justice. And once again, perhaps whilst my learned colleague is addressing this court, I can give some thought as to how such an order may be formulated to the extent that this court is inclined to go there. Again, the facts of this case did not really present us, or that debate did not happen, although it is an incredibly important point to it that I think has been overlooked by us as the applicant as well as the government respondents.
Yes, that is certainly something which should occupy the mind of this court, having regard to the effect any order that this court may give. Perhaps when you consider it, Mr. Courtney, you can also consider what would be the policy reasons for limiting retrospectivity. And I would like to move on to another question, another line, which has partly been addressed and raised by Justice Unterhalter and Justice Collopin, as well as Justice Mhlantla. Now, the carve-out that was made in Prince was for adult consumption in private use, or use in private circumstances, but not for public use. Has a case on the papers been made out why the carve-out in Prince should be extended to public use in respect of children?
Justice Theron, I think I would. This matter has a rather unique an unusual origin. There were no papers per se filed in order to attack the constitutional invalidity. Rather, what transpired was the High Court had a concern, and the Centre for Child Law was invited
Mr.
to.
Courtney, I'm very sorry to interrupt you, but I am aware of the time constraints. The court is familiar with the genesis of this matter. My question really is there anything in the papers before us which make out a case for the extension of the carve-out, the private carve-out in Prince, to a public carve-out in respect of children? Is there anything on the papers that justifies that, apart from the submissions and that have been made that use of cannabis should not be criminalized in respect of children? But as I repeat, my question is there anything on the papers that justify the extension of the private carve-out in Prince to public use in respect of children?
Justice Theron, I would say that there is. I think the government respondents in their papers did not, and in their affidavits that were filed, make no distinction between private and public, and in fact approach the problem on the basis of criminalization generally of cannabis. And there they put forward and set out their policies and what they believe is the appropriate response by government to the issue of cannabis use. And so in their own affidavits and that are filed in support of their view that the offense as it is unconstitutional, make out the very case that we need not distinguish between private and public use. The position is decriminalization, full stop, is unconstitutional. And that is the position of the Minister of Justice, if I understand the submissions, the affidavit correctly, as well as all the other ministers that were later joined. And that rather than prosecuting children, we ought to look at the alternatives. And then again, they set out what those alternatives are.
I may be wrong, Mr. Courtney, but I understood the large basis of the judgment of the High Court was that Prince excluded children from the carve-out, and that was unconstitutional. Excluded children from the carve-out made in Prince. Does the High Court judgment anywhere deal with the extension of the carve-out to public spaces?
It does not particularly do that, Justice Ron. The High Court...
The basis of the High Court's judgment is that it's unconstitutional to exclude children from the carve-out in Prince. Now, it's a different case, or it's an additional leg to say that carve-out in respect of children must be extended to public spaces. And surely a case must be made out for such extension. And I may be missing something, but I don't see a case having been made out for the extension on the papers that we have before us. The extension of the carve-out.
Indeed, just on, I think that the High Court approached the rights violations through the lens of it being a status offense, which would then fall squarely within the remit of the reach of the Prince judgment. So insofar as it interrogated the rights violations, it did that through that particular lens. However, the facts that underpin the affidavits of the ministers was not that narrow. And in fact, much is said about the importance to look to alternative systems in order to guide these particular children. And the importance of utilizing systems that we already have in place, as opposed to criminalization. So whilst the High Court, in addressing the rights violations, viewed it through the lens of a status offense, the evidence that I would submit that is before this court and that was tendered by the government respondents, and the underpinnings of the discussions on the limitation analysis in the High Court judgment goes far broader than that and deals more generally.
Mr. Courtney, in your reply, you'll refer us to those aspects of the evidence that you rely upon that cover the extension. If I may go to another point, please, another aspect, Mr. Courtney. Paragraph 110 of the Prince judgment. If you can refer to that, please.
Yes, Justice Ram.
Yes. Where the court was there dealing with the effect of the reading in. And it says, in determining whether or not a person is in possession of cannabis for a purpose other than for personal consumption, an important factor to be taken into account will be the amount of cannabis found in his or her possession. So once again, if I understand the applicant's case here, the applicant is asking this court to make a greater carve out, or actually there must be no limit as to regards the quantity. A reading of the Prince judgment says small quantities for personal consumption. And I asked the same question that I asked earlier. Do the papers make out a case why that carve out of a small quantity in Prince for adult consumption, for private use, should be extended in this case without limit to children?
Justice Ron, I think that it is important to stress that the applicant's case is not about creating a carve-out that allows for children to use and possess cannabis. That is not the case of the applicant. The case of the applicant is that the use of the criminal justice system as a tool to deter and prevent the use of cannabis is inappropriate. And I'm concerned that by discussing it along the lines of creating a carve-out for children may be perceived as there being some discussion about, well, children should simply be allowed to do that. And I don't believe that that is the applicant or the respondent's case. But insofar as the issue of the amount of cannabis is concerned, once again, it would be a factor when determining how to deal with this particular child. So if the amount is such that it is evident that it is meant for dealing purposes, then the child will be arrested and prosecuted. And we certainly are not asking this court to venture even that far. But if the amount is considered to be substantial, and I wouldn't know exactly how much that would be, but it would be a factor that would then be utilized in the assessment processes under the alternative statutory systems in deciding how the state is going to assist this child in dealing with whatever problems he or she may have.
And that will also be relevant to the question that my sister Justice Mplantla asked you about arresting of the child. Because if you look at paragraph 111 of the Prince judgment, it deals with when an adult can be arrested for possession. Would this court need to grapple with that situation in respect of children as well?
I would think not. And the reason I would say that it is not an issue is that if we accept that that the criminal justice system and the processes attached to the criminal justice system is not the solution to deal with children who are caught up in the cycle of cannabis abuse, then what ought to happen is that a member of the SAPS, who is likely to be the person who finds this particular child, they would then have to refer the matter onwards to their counterparts in the Department of Social Development. And those would all be factors. There would not be a physical arrest. And I would like to just draw a parallel in that regard with the position of the Department of Basic Education. There is no distinction in the South African Schools Act about 1 gram or 100 grams or 1 kilogram, insofar as how the Department of Basic Education is to deal with children who have cannabis on school property. The situation is that a child who is in possession of cannabis is subject to their disciplinary processes. And a child who tests positive, for instance, for cannabis, they're not excluded from the schooling environment, and no criminal prosecution commences from that particular test that resulted. So I think that insofar as children is concerned, what is important is that there is a linkage to services, because it is only through the linkage to services that we are able to deal effectively with whatever the underpinnings are of drug use by the child concerned. Without that kind of guidance, simply prosecuting them has thus far seemed not to have worked.
Mr. Courtney, can I also refer you then to paragraph 109 of the Prince judgment? Would this court need to undertake a similar exercise to what this court did in Prince? Look at paragraph A, for example. There the court says an adult person may use or be in possession of cannabis in private for his or her personal consumption in private.
I don't think that this court would need to venture that far, because what we aren't doing and what the position is that we're not authorizing children to consume cannabis. That is not the inquiry that we need to have, and an order need not be fashioned to make provision for those kinds of scenarios. The position is that children...
That would mean children could be in possession of any quantity of cannabis for any purpose.
Well, not necessarily, Justice Ron, because the law as it stands it still criminalizes supply and distribution and sale. And if a child is found in possession of however much is considered to be dealing, then the child will be prosecuted for being in that kind of quantity, being in possession of that kind of quantity with the intention, obviously, to deal in that particular drug. So much like if an adult was found with 1 kilogram or 2 kilograms of cannabis, they would likely be prosecuted not for merely being in possession, but likely to for purposes of dealing and supply.
The order that the applicant seeks, or the confirmation, would it be in any way contradictory to paragraph 109B of the Prince order, which specifically declares that the use of cannabis in the presence of children is not permitted?
I would submit not, Justice Theron. I think one can draw parallels with, for instance, how the Tobacco Control Act deals with smoking, and how the Liquor Act deals with liquor. Both are undesirable. Both are accepted to be undesirable products for children. And through both those pieces of legislation, the legislation itself at no stages criminalizes the child for using or possessing or dealing with it. It places restraints on adults from doing certain things that may well lead to the child being exposed to those harmful substances. So in much the same way that Prince says you cannot smoke cannabis around a child, that should be so, because it is harmful.
On the one hand, this court will say we need to protect children. You shouldn't smoke cannabis in the presence of children. And in another matter, in this matter, we say children can possess cannabis. Is that not a contradiction?
It is not a contradiction in the sense that what we're not saying is children should be allowed to possess cannabis. What we're saying is that when a child is found in possession of cannabis, the system that must deal with the child is not the criminal justice system. It is either the Prevention of and Treatment for Substance Abuse Act and or the Children's Act that must deal with it. So what we're doing, what we're trying to carve out is to say children should not be, they have no right like their adult counterparts to have cannabis in their possession. If they are found with cannabis in their possession, it is then for the system to determine the reason for that so that it can address the root cause of the problem. And one draws parallels quite easily again with reference to the Liquor Act and the Tobacco Control Act. And particularly insofar as the Tobacco Control Act, this court might, if this court has regard to Section 4, it's not dealt with in my head, but Section 4 deals with the prohibition in respect of tobacco products. And there it says—
Isn't it so that, if I'm correct, that children under 18 cannot buy tobacco products?
Indeed. So children, but the obligation is on the person who is selling, much like under the alcohol legislation, to ensure that the product that they sell is not, that the person is over the age. So the onus is on the adult. It is not on the child. And I don't understand either acts to criminalize if a child managed to, for instance, steal a bottle of whiskey out of their parents' cupboard or a box of cigarettes from an uncle. If a member of the police came across that child with that bottle of alcohol, with the pack of cigarettes, that they would be criminally prosecuted for that, for being in possession of that. And that is what that is effectively the way in which they're trying to prevent and deter is by visiting sanctions on those who provide access to these undesirable products for children, as opposed to criminalizing the children themselves.
I have detained you long enough, Mr. Courtney. Thank you very much. Thank you, Justice Madlanga.
Thank you, Justice.
Justice Madlanga, I know the time is long up, but I have an aspect which has not been dealt with in the relief, please. Mr. Courtney, in your heads at the end at page 23, you deal with the relief when you conclude that you seek. Specifically, secondly, you ask for a suspension of the order of invalidity. You do not mention a time there. Do you know how far the cannabis bill is at this juncture before Parliament?
Justice Majid, it is dealt with in my learned colleague submissions. I have been actively following the process, and I know that the calls for public comment have in fact closed, and they have had several workshops of which I have presented at one.
Okay, thanks. That's adequate. So around 24 months should be adequate, more or less.
Indeed, Justice Majid. I think that the process is close.
Yes, and then just finally, you ask then lastly, during the period of suspension, you ask for an interdict restraining SAPS and the NPA from arresting and prosecuting children. Now, the High Court imposed what I would call a moratorium on arrests and prosecutions. Do you still ask for this interdict against SAPS and the NPA? Over
Indeed,
and
Justice-
above that moratorium.
No, apologies, Justice Majid. I think then that there was a measure of confusion that I may have introduced into the heads. What we are seeking is that the moratorium stay in place pending the outcome
that's
of
what-
the law
Yes,
reform.
that's what, okay, that's what I'm asking. I'm asking then if you are actually asking for the moratorium to be retained as imposed by the High Court.
Indeed, Justice Majid, and I, as I mentioned earlier in my submissions, I will attempt to
Yes,
reformulate
I've heard that.
it, but yes.
Thank you, Justice Matlanga. Thank you, Mr. Courtney.
Mr. Courtney, you have, the 15 minutes is long up. You have, or maybe before that, we have read your written submissions. You have covered wide-ranging ground. You've dealt with the limitation. You've dealt with justification or lack of it. You have dealt with the breadth of what your client is asking for. You have dealt with remedy, that is retrospectivity, prospectivity, suspension, and now even the period of suspension. Is there anything else you still want to argue? I don't think there is. There can't be. This must be the terminal point now.
Indeed, Justice Madanga. In conclusion, though, I would like to simply add that I think that any judgment that this court gives is important for the legislative process that is currently underway. And this court should be mindful of the fact that there is currently a legislative process that is underway, and that this judgment will certainly resonate within that process. And I think that it is important that guidance be given to the legislature in this regard on this very complex and controversial subject. But then those are the submissions of the applicant, Justice Madanga.
Thank you very much, Mr. Courtney. Yes, Ms. Raja. Let me just look at the time, colleagues. Should we, maybe let's take the break now and resume at 25 past 11:25. Quarter chair.
Thank you.
Thank you. Sorry. Court will adjourn until 11:25. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone and rejoin with video and sound when the hearing recommences at 11:25. Should you exit, you may use the same link to rejoin the hearing. Thank you. Justices, all counsel are online.
What about my colleagues, Ms. Suma?
Thank you.
Oh, yes. Yes, Ms. Raja?
Justice Madlanga and justices, we have filed 2 sets of heads. The Minister of Justice has filed 2 sets of heads, both in the High Court and before this court. We don't propose to go through everything in those heads. We stand by them. The Minister does not oppose this application for confirmation of the order of the Quarter-Co to the extent that it invalidates Section 4B of the Drugs Act as amended. And I must emphasize the word as amended, because it was amended by the Prince judgment, and as amended to be inconsistent with the Constitution and invalid to the extent that it criminalizes the use and possession of cannabis by children. We propose to deal with 3 topics. The first is to deal with the Minister's preliminary submissions. And then secondly, we will demonstrate the basis upon which the Minister of Justice agreed to the declaration of invalidity. And lastly, we will deal with remedy. The genesis of the Minister's participation in the Quarter-Co came from the judgment of the Quarter-Co of 1st February 2019, wherein the justices said, Judge Opperman and Judge Mokgatleng said, asked the question whether, in view of the fact that the 4 children were before court after having tested positive for DAGA, in fact, did they even commit an offense? And they asked that question in view of the Prince judgment of this court. And so they invited the Minister of Justice to come and make submissions before that court. And the minister came before the court and said, yes, it does remain an offense in relation to children, because the Prince judgment of the Constitutional Court made it very clear in paragraph 108, in paragraph 129, 10, read with 13, that the ambit of that judgment and the ambit of the orders were only insofar as adults, and they did not relate to children. And this, again, was also consistent with the orders that were made, or even the comments that were made by the Western Cape High Court in paragraph 107, which made a comment that that case was not dealing with children at all. So I will be remiss of me, Justice Madlanga and justices, if I do not make it abundantly clear why the minister decided to take the position that he took. The position that he took was because he wanted to protect children. That position was not condoning the use and possession of cannabis by children. The minister, and indeed the other ministers that later were joined to support the Minister of Justice, accepted that cannabis has serious health and social consequences, both for adults and for children, and most especially for children. But the minister felt compelled to step in order to protect children. And he did so for many reasons, which are set out in our heads of argument, but I'd like to just mention just a few. The first is that the Minister of Justice felt that it was not rational and fair to still impose a criminal offense of the use and possession of cannabis by children when it had been decriminalized in respect of adults after the Prince judgment. The Minister of Justice felt that there was no justification for such a drastic measure to be taken in relation to children, because what it meant was that the children would be taken through the criminal justice system, albeit through the Child Justice Act, but they will indeed still be arrested, a docket opened against them. And the Minister of Justice thought that that cannot be a justification in light of the purpose of the Act, especially in circumstances where the Minister of Justice felt that there was legislation available to counter or to help or to be that is in line with the purpose of the Drugs Act in the first place.
The 5 minutes is up, Ms. Raja. So
Thank you, Justice.
I put questions to you now, but please continue with your argument.
Thank you. The Minister of Justice felt that it is still important for government to protect children from drug abuse, and that it would be in the best interest of justice to remove the use and possession of cannabis as an offense, in so doing to remove the children from the criminal justice system. The minister's approach was fortified by the affidavits that were subsequently submitted to the court by the other ministers, and the Minister of Justice had invited the other ministers, because what the Minister of Justice was actually saying was there are other less restrictive measures, but they are found in the Children's Act, they are found in the the Prevention and Treatment of Substance Abuse Act. I shall refer to it as the Substance Abuse Act because it's a bit of a tongue twister. But he says because that act is a collaborative responsibility.
Excuse me, Ms. Raja. One of the significant debating points earlier you would have picked up is whether the scope of the decriminalization in this matter goes way beyond Prince. And I want to get some clarity whether that is indeed the minister's stance. And I ask for that in the context of paragraph 30 of the High Court judgment, where that paragraph is preceded by quite a considerable discussion on the rationale for protecting children. But what paragraph 30 says, and this is after the High Court sort of summarizes the various submissions from the various ministers, says the following: it was accepted and indeed emphasized that the selling and provision of cannabis to minors and the use and possession in public will continue to be a criminal offense. Now, Section 5 of the Act deals with selling, and I think that's okay because that's still preserved. But it seems that it was the common stance of government, certainly, and that the court took cognizance of this, that the use and possession in public would continue to remain a criminal offense. Are you saying that the minister supports decriminalization also to the extent that it covers use and possession in public? Because that's the critical point that we've been debating.
That was my next point, Justice Kalapin. Thank you for taking me quite quickly. I was going to emphasize that the Minister of Justice concession was not a blanket concession. It was limited, and it was limited only in respect of the use and possession as per the amendment, and that's also the wording that is used in paragraph 1 of the order, as amended. And I would submit that the word as amended in paragraph 1 of the order, it meant that as amended by the Prince judgment. And you're quite right, Justice Kalapin, I was going to refer to the justices to paragraph 30 of the judgment of this court, where it was made abundantly clear that the Minister of Justice is saying that to the extent that there is still a criminalization in terms of dealing, in terms of sale, in terms of use in public, and in any other respect where it remains a criminal offense in respect of adults, that should still apply to children.
So just to get in there, the amendment to the Act, was that an amendment effected by Parliament post-Prince, or are you saying that the judgment of this court constituted an amendment?
I'm using the term loosely because it by
Maybe
effect,
a bit too loose, Mr.
When you read paragraph 129,
Yes.
15,
I'm saying maybe a bit too loose because one needs to give clarity to law enforcement. And if there's the legislation that has not been amended by Parliament, then I'm not sure whether the submission that the judgment of this court in Prince constituted an amendment. That might be a bridge too far. And that's what may have caused the conceptual difficulties we've experienced earlier. Yeah.
Yes, if I may just put it in this way, the judgment in Prince says that if the government does not remedy the reading in within a certain period of time, which is 24 months, which has passed, then the reading in is effective. So when we refer to when we refer to the status offense, or when we refer to the fact that there has been a differentiation between children and adults as a result of the cannabis judgment or the Prince judgment, we refer to that effective, we refer to the fact that the reading in has effectively now amended section 4B to now exclude only adults, to include adults to the exclusion of children.
Thank you, Ms. Raja.
I must say, you've already said it, Justice Kolapin, but I must also emphasize that this matter does not also cover the Prince judgment insofar as it went to the another level of permitting the cultivation of cannabis by adults, because that was dealt with in terms of section 5B, which was not challenged in these proceedings. So it is important again to then also say that the government is not with the amicus on this question that children must be, that section 4B must be declared unconstitutional in its broad extent to which my learned friend has argued this morning. If I may just move then to the next topic, the test is very clear, and my learned friend said it for confirmation. We submit that we agree with the declaration of constitutional invalidity of section 4B to the extent that it was, it infringes or limits the rights of children in terms of section 9.1 and section 9.3 of the Constitution. Section 9.1 deals with the right of equality and equal protection and benefit of the law. And section 9.3 deals with the right not to be unfairly discriminated on the basis of age and status. And that's why we have been referring to the term status offense. The law is very clear and it's quoted in our heads of argument, but the test in relation to that has been the test that has been put forward by the Constitutional Court and as reflected in Willman.
Ms. Raja, I'm sorry to interrupt, but I'm a little bit confused as to what it is that you're seeking confirmation of, because could you go to the High Court order? It's at page 805 of the papers.
I'm there, Justice Unterholzer.
Well, you want us to read as amended to connote together with the carve-out approved in Prince.
Correct.
Well, then you're asking us to declare that 4B with the carve-out in Prince is unconstitutional, is invalid.
Is invalid.
So Prince is invalid to the extent that it criminalizes the use and possession of cannabis by a child, but Prince doesn't do so. 4B does so. And what I'm equally unclear about is that you've just made the submission that you don't want 4B to be decriminalized in its entirety. So what is the limitation you want us to read into the extent of constitutional invalidity in respect of children in respect of section 4B? What's the language you want us to adopt? Because I'm very unclear now as to what your position is.
The language that we accepted that the position that was put forward by the minister in the quarter call was that Section 4B was unconstitutional to the extent that it infringed upon the rights of children as secured in Section 91, 92, and Section 28, 1D and Section 28.2. So if you follow the arguments there, Justice Unterholter, it was that we're saying that the Prince judgment created a status offense. So to that extent,
but I'm sorry to interrupt, but are you saying you seek the extension of constitutional invalidity to children only in respect of children using or possessing small quantities of cannabis in private? Or yes. Are you saying, well, that's not what the order of the High Court says, and it doesn't appear to be the order that you have sought in your written submission. So again, if you tell us precisely how you believe the order should read.
May I try and formulate it in a way that I believe would give effect to what the minister would like? It would be, and maybe I should read it in line with the Prince judgment, if I can put it in, because what I would like it to read is to replace adult from the order that is in Prince and to put it to mean persons. So it shouldn't be just adults, it should be persons. And I think if that order is then, if it reads in that way, then it would cover both adults and it will cover and children as well.
Well, perhaps you'll give some attention to precisely how you believe our order should be framed, because at the moment there seem to be a number of positions, and the position of the minister is not entirely clear to me, at least as to the formulation of the order that you're seeking.
Justice Unterholter, I will craft an order that the Minister of Justice would prefer, if you are minded to confirm this, having heard my arguments.
Yes, thank you.
So in relation to whether Section 4B in fact infringes or limits the rights of children in terms of Section 9.1 or the right of equality vis-a-vis children, the inquiry is whether there has been a differentiation between individuals or groups. And the second leg of the inquiry then is, does the differentiation have a rational connection to a legitimate government purpose? So the answer to the first question is yes, it does, because what happened was the effect of the Prince judgment was that it differentiated between adults and children. And then we move to the second one, is there a rational connection to a legitimate government purpose for that? We submit that to the extent that adults can use or be in possession of small quantities for personal use without committing a crime, whereas those children who do the same can commit a criminal offense, we say that is not rationally connected with the purpose of the Drugs Act, because what the purpose of the Drugs Act is, when this is reflected also in paragraph 64 of the Prince judgment, it is to protect children against drug abuse. So, and so exposing, yes,
I'm also sorry to interrupt you. I had understood from Mr. Courtney that this case is not about allowing children to use and possess cannabis. It's about decriminalizing the use or the possession of cannabis in children. I understand your argument now a little differently to that. you are saying that Prince allows adults to use cannabis for private consumption. Children are not allowed to use or possess it, and that differentiation cannot be justified.
We say that the differentiation, the effect of that differentiation is that you have children still being dealt with through the criminal justice system. It remains an offense for children. Once you decriminalize for adults, then it remains an offense in relation to children, and therefore children are still taken through the criminal justice system. And my argument that I'm putting forward now is that if the purpose of the Drugs Act is to protect children against drug abuse, then is taking them through the criminal justice justice system still rationally connected to that purpose of protecting them? And my answer is that that is not correct. And I would like to just give an analogy to you, Justice Theron, that if we have Thabo and Thabang who are found in their backyard smoking weed, and Thabo is 17 years and 17 years and 11 months old, and Thabang is 18 years old. But then Thabang is protected because of the Prince judgment, yet Thabo can be put through the criminal justice system by being arrested, the docket opened against him. So we're saying that if the point is to protect Thabo from drug abuse, then taking him through the criminal justice system is not rationally connected to the purpose for which the act, especially now that the offense has been decriminalized for an adult, Thabang, in this scenario that I have just given you. So yes, the whole point, where I agree with my learned colleague, Mr. Courtney, is that the point is to decriminalize, to remove it as an offense. And that will bring me to the next inquiry, because the next inquiry in terms of section 9.3 is whether is this unfair? And we would submit that it is presumptively.
Before you move to your next point, please, in response to a question from Justice Unterhalter as to the order of confirmation that the respondent would support, you said the minister would prefer a deletion of the word adult in the order given by this court in Prince. Please, can I ask you to look at the order in Prince, in particular paragraph 10. If I understood you correctly, you would ask this court to make an order similar to that of paragraph 10 of the order on Prince, with the deletion of the word adult in the last part of that order. Is that right?
So I was looking more into paragraph 129.13, Justice Theron. And I would like an opportunity to just formulate it a little bit better, but that's what I had in mind when I was answering Justice Unterhalter, was that during the period of suspension, that 4B, I think it's 6, or is it 7? 7, and it says in the case of an adult or a child or
Ms.
together
Raja?
or to person.
Ms. Raja, the declaration of invalidity is in paragraph 10 of the order. Paragraph 13 relates to the suspension of the operation of the order of invalidity, but the actual order of invalidity appears in paragraph 10.
So again, we would like it to then be extended to all persons with the deletion of adult.
But the effect of that order, if it was to be granted in the terms that the minister seeks, would be to allow children to use cannabis in private.
Justice Theron, the whole point of the Minister of Justice concession is that you decriminalize the use and possession by children. And so
I am with you, Ms. Raja. The question is, how do we achieve that? Now, I'm interrogating your suggestion or your proposal to the court that we can achieve that by deleting the word adult from the order made in Prince. And that is what I'm discussing and debating with you, and whether the order in Prince suffices to decriminalize possession in children, or does the order in Prince go further? Is that what we want this court to do? Do we want this court to say that children can use and have in their possession cannabis or a small quantity of cannabis for their private consumption? There's a difference.
Yes, I understand there's a difference. If this court is with us in terms of the fact that there has to be a decriminalization of the use and possession by children, and the only problem is whether should it be in private, and should it be in private, or to the extent that it was done in Prince, we would submit that the intention of the Minister of Justice is that when a child is found in possession or using the cannabis, there are avenues, and that's where my next argument was going to be, that there are the reason why the Minister of Justice was more inclined to accept that there must be a decriminalization is because he's saying there are other alternatives that are able to deal with the purposes.
My question, Ms. Raja, is how do we achieve the decriminalization? What type of order does this court make to achieve the decriminalization? I don't think by deleting the word adult simply in Prince, we might achieve that. So I'm asking you for your assistance as what kind of order this court will give to decriminalize that offense instead of making it legal for children to use cannabis.
May I ask Justice Theron that during the break, while my learned colleague is doing his reply, for me to craft an order that will decriminalize, because it is still important to decriminalize the use and possession by children. What I do understand the court to be saying is that, but we don't want it to say, it is okay for you to possess it, it is okay for you to use it. And to that extent, the minister is aligned with that, because that is what the minister is saying. But I want to also remind you that when I come to the question of remedy, I will try and demonstrate to you, Justice, to the justice of this court, that the intention of the legislature is to, in fact, remove cannabis completely from the Drugs Act. So this measure that you're going to be putting in is going to really be a temporary measure, because the legislature is intending on doing a completely different, on regulating the use of cannabis by adults, and the way in which the adults must protect children through a different bill, which is the Cannabis for Private Use Bill. So that I'm going to deal with more thoroughly when we get to the question of remedy. So this is going to be a temporary measure, and for that reason, that is why we, the respondents, were more inclined to agree to this temporary, the temporary measure that was in place, but that was put in place by the High Court, because there is already the legislature has already carved out a way in which it says that we're going to remove cannabis from the drugs Act completely in relation to cannabis. So if you give me that moment, we will try and figure out, we will try and assist the court in carving out at least an order that is going to be temporary, that is going to be applicable temporarily while we're still waiting for the bill to kick in as an act.
Excuse me, Miss Raja.
Yes, Justice Matoko.
You see, what my difficulty is the approach by the minister as well as the applicants, Center for Child Law. Correct me if I'm wrong. There does not seem to me to have been a proper interrogation of what the judgment in Prince says, and comparing that with the order of the High Court. There seems to be, to me, that there is some disjuncture. I'm just putting this to you that as you formulate your order, take into consideration the fact that Prince, as it is, and the High Court's order is more broad. And Prince is limited insofar as it deals with adults in their private space. The High Court order does not say that. And you have to factor in the fact, I think it was put by my sister Teron to Mr. Courtney, whether this particular case has been made or not. Just think about it as you prepare, because that causes me some difficulty as to where are we going, because if Prince forms the bedrock of the High Court's judgment, and which is narrow, and the High Court's order is more broader, what do we do with the two and the minister's position thereabout?
Thank you, Justice Matoko.
Ms. Raja, the 30 minutes is up. How much more time do you want?
I would also appreciate the 15 minutes that was afforded to my learned friend.
All right, you will get it, Ms. Raja. Mr. Courtney? Mr. Courtney?
Yes, Justice Madanga.
Yes. May I say to both of you, counsel, that you've seen the concerns that my colleagues have around remedy, and Ms. Raja has offered to put together a draft order. Rather than us having something rushed and prepared during argument, I suggest that council should prepare something, hopefully something that they will reach agreement on, and then file that with the court after argument. Not necessarily today. I don't know whether you want us to formalize it and issue directions, but say within 5 days from today. Is that possible, counsel?
I'm happy with that. Justice
Madanga, the only concern I have, I'm happy for us to do that, and I would appreciate the time it means that I can sit and consult with the staff at the Center for Child Law. But it would seem as if myself or the Center for Child Law and the government respondents have parted ways.
Don't hide, Ms. Raja, don't hide. It's fine because I'm discussing with both of you, yeah.
Okay.
Yes. Oh no, in that event, it's fine even if you give us separate drafts. That's in order as well.
As the court pleases.
I think 5 days is too long. Maybe 3 days.
3 days is sufficient for.
3 days is also sufficient with us. I was also going to indicate, Justice Madlanga, that for us, for the Minister of Justice, the Prince judgment, and I think this is in response as well to the question posed.
Let's not argue the point. Let's say, it was just an invitation, and in fact, extending, the opportunity to both of you to just file with the court. All right.
Justice Madlanga, if I could also just ask through you that the order deal with the question of retrospectivity as well, please.
Thank you very much. Thank you.
Sorry, through you, Justice Madlanga, just to complicate the situation, and it may not be before us, but it's a matter that concerns me. Both the applicant and the respondent says that they don't want a perpetuation of a status offense. But even if we give you all the relief that you ask for, we will continue to perpetuate that, because the question of 5B is not before this court. And what 5B does, it provides immunity from cultivation for adults. But there's no such immunity, and there won't be such immunity even after a order of invalidity is confirmed by this court in respect of cultivation by children. So I just leave that with you. It might be a fight for another day. But the status offense being offensive will continue to exist. And it's something that may have been overlooked at the level of the High Court. May not be the High Court's fault, it was simply not squarely placed before that court. Yeah.
Thank you. 3 days then, counsel, for your individual draft orders. Your 15 minutes starts now at 1 minute past 12, Ms. Raja. Please continue.
Thank you, Justice Madlanga. I wanted to respond to Justice Matopo's question, because I think that the premise from which the Minister of Justice moved from, that the Prince judgment created a status offense. And for that reason, and the Minister of Justice did not just say, we're going to rubber stamp what the Center for Child Law was saying. Says, I'm going to come and I'm going to make submissions for why we say that should not be the position. So I do, to that extent, I accept that we did not interrogate. There was not a thorough interrogation of the Prince judgment as vis-a-vis this case, because the Prince judgment, it was immediately appreciated that it did not deal with children, and it was dealing with a separate right, and which was a right by adults to use or possess and cultivate in their private spaces. And hence why I immediately appreciate the court's concerns about the order, because they're saying we can't mirror the same order, because then it will perpetuate, it will mean that children are now in possession, and children can now even be used as mules, as drug mules, if the argument of my learned colleague is actually taken into account. So we will give that draft order, which in our submission should protect children, should decriminalize, but still then protect children from the use and possession of cannabis.
Ms. Raja, I'm sorry to take up some of your time, but the problem isn't just a question of remedy. It's a conceptual problem, because Prince is about rights of privacy, and hence it's about legalization that is consistent with the exercise of the right of privacy. Those rights are not enjoyed by children. So you're concerned with the consequences of Prince and decriminalization, not legalization, decriminalization, which are not the same things. And then the question is, if this is about decriminalization, then how far does it go in respect of what kind of conduct, and Are these papers sufficient to justify an order, and what sort of order? These are some of the questions which don't seem to have been adequately thought through by the minister.
Justice Unterholter, the minister, I would submit without, the minister did put up and say, well, we understand Prince was dealing with privacy. The minister says, I'm now here dealing with the right to equality, the right to the discrimination, and also the right to the best.
But Ms. Roger, there isn't an equal right that children have to smoke cannabis in their in the privacy of their homes. You've accepted that proposition. So now we're engaged upon a different inquiry, which is, for what purposes should the criminal law in respect of the use and possession of cannabis by children be decriminalized? Not to bring it into conformity with Prince, but in a more general way under the Constitution. That's a different enterprise, and it doesn't seem to be one that has been fully squared up to.
I would submit that this court, before this court, the Minister of Justice has put forward a compelling argument to demonstrate to the court that there are less restrictive measures in place through the Children's Act and through the Substance Abuse Act to protect children.
Well, then I come back to the question: how far do you want us to go? Is it only in private? Is it in public? What's the differentiation between them when there are alternative measures in respect of both kinds of conduct? Why do we stop only at private use and possession?
Because Justice Unterholter, you must recall that we said this is an interim measure that is going to be put in place whilst the legislature has already but
that can't be correct, Ms. Roger, because you're concerned with the rights of children that reflect what the Constitution requires, irrespective of what final regime the legislature might deem appropriate.
And during this limited period, Justice Unterholter, Justice Madlanga has said, won't you please go back and craft an order that will at least protect those rights of children in the interim until that the legislature does.
Thank you. I've heard you. Thank you, Justice Madlanga.
Then that brings me to, I think I have 10 minutes. Justice Madlanga, we have dealt with this issue in our heads in paragraphs 83, where we demonstrate that there are less restrictive means available to achieve the purpose, and therefore criminalization is not an option. And those less restrictive measures, if I may just demonstrate quite quickly, is that Section 53 of the Children's Act, for example, says, it contemplates that anybody acting in the best interest of the child may approach the Children's Court. And Section 151D of the Children's Act also says that a child in need of care and protection includes a child that is addicted to a dependence-producing substance and who is without any support to obtain treatment for such dependency. And Section 156(1)(j) as well says, if the court finds that a child is in need of care and protection, the court may make an order that is in the best interest of the child, and that child can also be admitted as an inpatient or as an outpatient. Section 156(4) also provides that if a child is in need of care and protection, the court may nevertheless also issue an order that they be admitted. So what you see is that the very same measures that the Child Justice Act were trying to put in place, which is to divert children and put them and to divert them into these rehabilitation centers where they will get treatment, is still available through the Children's Act. And the same is also possible through the Substance Abuse Act. Again, through that act, Section 32 provides that a person can be voluntarily admitted. They can also be involuntarily admitted. A parent can take them through the process. So if the true purpose is to actually is to curb abuse of drugs by children, then the minister says, and supported by other ministers, they say then there are adequate and less restrictive measures that are in place through the Children's Act and the Substance Abuse Act. Again, the next point is that we submit that the Section 4B infringes Section 28(1)(g) and 28(2) in that incarceration or putting a child through the justice system is harsh as compared to adults in the similar position who are found in possession or in use of cannabis, and it is not in the best interest of the child.
Sorry, Ms. Raja, to interrupt you. I just want to get clarity. So the minister is saying if a child is found in possession or found using cannabis, that child must not be arrested, must not be prosecuted in the ordinary courts, but must be channeled through the Children's Court or through in terms of the Children's Act and the other act, the Substance Abuse Act.
Correct.
I asked Mr. Courtney about the process. How will that be achieved, that process, in terms of the two acts?
The ministers attempted, the various ministers attempted to demonstrate the processes in their various affidavits. And if I can just try by just even starting with for example, the Minister of Education. The Minister of Education says, when we deal with children who are found to be, even if they are tested by the police or who are found to have these problems with drugs or who are found to have spoken Daha, a social worker is able to take them through to a court, or that's why I pointed out that in terms of the substance of the Children's Act, any person that acts in the best interest of the child can take them through. So even the police, and even the police, I think the Minister of Police demonstrated in the affidavits that there is an instruction note that says if they come into contact with a child that needs care and protection, there are mechanisms in place through the Children's Act for them to be able to take them through that civil system as opposed to the criminal justice system. So again, Justice Mhlantla, the Minister of Social Development as well emphasized that the implementation of the Substance Abuse Act is the responsibility of all national ministers and all these different disciplines. And they are expected that when they do deal with these instances, that they implement the act, and it is done so to the best interest of children, and I suppose also for adults. And in all instances, the police are able to intervene. So it doesn't mean that the police are taken out. What is taken out is the fact that it's now an offense, because once it is an offense, the police arrest, they open up a docket, and we know where it leads to in the end. It may lead to even having a criminal record.
So Rajab, at a practical level, how does that happen? The police arrest Thabang at the roadblock. Thabang is found in possession of 2 or 3 bags of cannabis. What must the police do to Thabang?
Justice Matopo, again, perhaps I don't want to go back and forth in terms of quantities or in terms of of that. But what I do believe is that the police, when they are confronted with such a situation, they're able to ask themselves, is there a problem of drug abuse here? How can I channel this person through the processes in the children's court and through the processes and also through guardians? This here we are dealing with minors, remember.
Can I interrupt you? Can I tell you why I'm asking you that? Is because what the Minister of Education and the Minister of Social Development seem to be focusing their attention on is children found in possession of the cannabis at the school premises. But if you take them out of the school premises, one doubts whether their jurisdiction would extend that far. And it becomes a police issue. And if it's a police issue, what do we do with it as a police officer? I've arrested a person at the roadblock, and who happens to be your tabang, who's 2 months shy of 18 years. And then what do they do with tabang?
Hence why we said my submission initially, Justice Matopo, is that treating tabang and tabiso differently, because tabang is 18 and in fact, you just switched the name. Tabo is 17 years old and tabang is 18 years old, is problematic, because if a minor, if our argument is that if a minor is, if an adult, if let's say the police stop a car and in that car is an adult as well as a minor, and both of them are in possession, it seems to us, to the minister we submit, irrational that you would leave the adult and take tabang. And that's why I would submit that's why we submit that when one looks at the new bill that is going to come, the court, the legislature is now trying to criminalize it at the point of or regulate it, maybe let me use that word, it regulates it at the point of the adult. It puts that accountability on the adult, and it says you cannot you cannot allow a child to be in possession. Hence why we say that cannot be so. It cannot be rational that you in a car, the policeman stops the car, there are two adults, there's an adult and a child, and then they arrest the child and leave the adult. And that is what the Minister of Justice is saying. He says, in those circumstances, then the police must be able to take that child through a different process that is not going to lead to the child being taken through the criminal justice system. And I do appreciate the court's concern about allowing children to be in possession and using, and that order that's going to be crafted will deal with how this court must address that issue.
The 15 minutes is up. How much more?
15 minutes is up, and I just want to conclude, and I think I've addressed it, which is the question
how much time do you want for that?
3 minutes. I've already done it. The remedy is that we will craft for the court an order that is consistent with what the minister is asking, which is in line with protecting the children. And in relation to also the question of retrospectivity that Justice Theron asked us to also touch on, the minister will do so. And I just wanted to highlight in relation to the discourse that Justice Theron had with my learned colleague earlier on, that it is contemplated in the coming bill that there will be an automatic expungement of records and sentence in relation to those children who have been incarcerated in terms of Section 4B. So if during this time we will try and ensure that we get that order that is going to be in line with at least the purpose for which the Drugs Act, or even the Child Justice Act and the Children's Act and the Substance Abuse Act is trying to do, which is to protect children.
Then there's para 2 of the order of the High Court. the moratorium. Are you supporting that order, or you heard the questions that were posed to your colleague?
We had the questions that were posed, and in crafting the order, we will have it in mind, but we had supported that moratorium on the basis that we, as we have submitted, that the moratorium also goes on. It says that it does not in any way prevent or prohibit any person from making use of any civil process and or procedure to ensure that a child receives appropriate assistance and or intervention for cannabis use or dependency. So at all material times, what was envisaged is that you do away with the criminal, the offense of it, but not to allow the child to be in possession or to prohibit any form of ways in which the police or anybody that is involved in this multidisciplinary approach to be able to assist children. So paragraph 2, we will support, but we will try and craft an order that covers both paragraph 1 and paragraph 2 and the concerns that have been raised by the court.
And the suspension of the order, suspension period.
The suspension period, we submit, Justice Majid suggested 24 months. In our heads of argument, we had said 12 months. Yesterday, when I took instructions, I was asked to ask for 24 months, but the bill, as we have submitted in our heads of argument, that it is at an advanced stage. Comments have been received. It's just waiting to go through the parliamentary process. So we do ask for the suspension for the 24 months.
Thank you, Justice Madlanga.
Thank you, my sister. Anything else, Ms. Raja?
Nothing else. Thank you.
Thank you very much, and thank you very much to both counsel. Judgment is reserved. Court adjourned.
Thank you. The court pleases.
Concluded. The host will now terminate the meeting.
The reply by the yes.
I am so sorry. I hope everybody is still here. I hope everybody is still here. Reply. That's probably because Mr. Courtney had said not likely to respond, but only if. So, Mr. Courtney, are you replying?
Indeed, Justice Madlanga. I think several questions were asked of me to ponder, and I hope to have resolved most of them. And I will apologize if I don't touch on them. There were a few, and I've tried my best to deal with them all as I understood the question.
Justice Madlanga, I think we've lost Justice Unterhalb. I think he's left the
oh gosh,
the hearing. I don't see him on the screen yet.
Let me quickly call. I caused the confusion, colleague. My apologies. Let me get off. My colleague is joining now, colleagues and counsel.
Thank you. I'm back.
Thank you very much. Thank you, my brother. Yes, Mr. Courtney.
Apologies, Justice. I had some difficulty getting the mute button. As I was saying, Justice, I'm going to attempt to answer some of the questions that were posed to me during my address, and I hope that I answer them sufficiently. Perhaps let me start with, I believe it was Justice Colopin's question about, are we not inadvertently creating a status offense vis-a-vis adults? And in my address, I said that wasn't the case. And I think it's important to stress, and unfortunately, with all the questions, I couldn't get the authority for the proposition, but I can comfortably say that the authority exists by this court, that the legislature is entitled to differentiate between adults and children. And the law, in fact, has and always will differentiate between adults and children. And it's an important aspect of the law that we do so, because the needs of children are different to those of adults. So we treat them differently. And that is evidenced by the fact that, for instance, we even have a separate justice system for them that has many protective measures that are solely to the benefit of children and not adults. Then there was a question, two questions by Justice Unterhalter. The first was whether or not there could be anything said about protecting children through criminalization, particularly from them being exploited. I wasn't able to find a case that puts it eloquently and that I could borrow liberally from. So I will give it my best attempt to deal with the issue, and that is, those types of considerations should never play a role in determining whether or not a person should be criminalized. Firstly, those same sentiments were expressed in relation to the enactment of the Child Justice Act, that adults would use children because they would be treated less severely by the criminal justice system. And I don't believe that there is any evidence to support that proposition. The second, and it is a rather unfortunate example, but the only example I could think of on my feet, is if we say that it is okay to protect, in order to protect people, we are going to criminalize them from doing certain things. It is akin to the rather ludicrous debate that is sometimes had about women and their dress codes. And I would say that by parity of reason, whilst we will not police women and their dress codes in order to protect them from men, likewise, we shouldn't be punishing children to protect them from adults. And I would submit that it is it follows quite, by parity of reasoning, it should apply, the same sentiment should apply. Insofar as Justice Unterhalter made reference to the deterrent effect, I would like to refer this court to its judgment in Teddy Bear Clinic, particularly paragraphs 87 and paragraphs 88. There the court deals in broad brushstrokes with deterrence, and why generally the nominal effect of deterrence usually serves as a justification. The situation here is starkly different. Here we have on affidavit by the various ministers and readily conceded in the submissions that there is no deterrent effect. There is no need for us to consider the issue of deterrence any further. Then there were a couple of questions from Justice Theron. Firstly, she asked about the evidential basis, and I would like to refer at a quick glance, I would submit that if one has regard to volume, I believe it is volume 5, at page 478, it is an affidavit by the volume 5, an affidavit by the Department of Education, and particularly at paragraph 6 there. There it repeats the assertions made in the heads of argument by the minister as to why it is unconstitutional. Save for paragraph 10.1, it quotes extensively from the heads of argument, and save for paragraph 10.1, which is the only occasion in which the minister deals with the Prince judgment, the Minister of Basic Education affirms from the balance of that, and that is simply that there is no justification, and this is done without qualification. There is no justification for the incarceration of children and the treatment of children as criminals and not as victims when they are found in possession of cannabis or using cannabis. And they go on to elaborate on that and confirm what the Minister of Justice had said in paragraph 7. Similar statements can be found in relation to the Department of Social Development at page 645, at paragraphs 14.2 and 14.3, and I believe 16 onwards. And then at page 734, the Department of Health affidavit at paragraph 14, read with paragraph 60. And what one sees if one interrogates those affidavits is that there is an acceptance by the various ministers without qualification that treating children as criminals for possession is an inappropriate response. And you cannot divorce those two statements from, you cannot divorce that from private versus public debate. It is either inappropriate because of the harmful effects that it has on children generally, or it is not harmful at all. What you cannot say, and what doesn't follow from those types of submissions, is that it is only harmful when it is done in private, but it is not harmful when it is done in public. And I don't read the submissions. I hear the argument being made now that there is supposed to be this differentiation, but the argument for the relief finds equal application wherever you find a child with cannabis. Justice Theron also mentioned and asked about the issue of retrospectivity.
Mr. Courtney, just to interrupt you one moment. So would that reasoning then extend to dealing as well under Section 5? I know it's not before us, but by parity of reasoning, we should never criminalize a child who's a drug dealer.
Not at all, Justice.
Well, tell me what the point of distinction is.
Well, adults aren't allowed to deal in drugs. And what we're saying is that the appropriate response for when we find children who are using or possessing drugs is that the appropriate response is not a criminal justice response. We're still demanding a response.
No, I'm asking you about a child who is dealing. You say criminalization is the wrong response. Does that apply to a child who is dealing?
Justice Salter, I haven't considered the question, but I would tend to suggest in very broad brushstrokes that as a general proposition, criminalization is likely not, has no deterrent effect. But unfortunately I haven't, and I properly considered the implications insofar as dealing is concerned. The centre does not condone dealing. And insofar as my instructions on that score are concerned, the issue of dealing remains a crime. And if a child is dealing in cannabis, then the prosecution should follow, unless there is a complete rethink as to how South Africa deals with drug abuse differently. But I mean, as things stand, dealing would still constitute a criminal offence.
Thank you.
Justice Saran made mention of the issue of retrospectivity and asked for the authorities dealing with it. I think that a synopsis of the issue of retrospectivity is set out by this court in Centre for Child Law versus Minister of Justice at paragraph 73. And there the court discusses both the Bulwana case as well as the National Coalition case. And that gives obviously guidance insofar as retrospectivity is concerned. But I would also like to draw the court's attention in that regard to the alternative approaches that this court has taken in relation to dealing with criminal conduct that has otherwise been decriminalized. Firstly, there is the option of expungement, as was done in Teddy Bear Clinic, and the order of this court in Teddy Bear Clinic deals quite neatly with how the issue of expungement should be dealt with, and places it on the minister to go ahead and find these cases and expunge these cases. The other alternative approach is the approach that was opted for in the J decision. It is likewise a decision to expunge, but there, rather than placing any obligation on the ministers, that the legislation itself ought to deal with that issue so as to ensure that historically people who have been convicted, that their rights are effectively vindicated. And as my learned colleague suggested, is that is already in the pipeline. I believe that then those were the only issues that were required of me, unless I've missed a question. Those would then be the submissions of the applicant.
Thank you, Mr. Courtney. Again, thank you to both counsel. Now the court will adjourn for real. Court adjourn.
As the court pleases.
Thank you. Today's proceedings have concluded. The host will now terminate the meeting.